Welcome friends, today we will discuss one of the landmark judgment given by Supreme Court recently on 8th of April 2025. It's regarding governor, and that's what you are reading is right, quite clear. Can governor delay the bills indefinitely? This question will be answered in today's video. So the video is very important for pre-mains as well as interview. What are the things we are going to discuss? First of all, why it is in news? What's the Supreme Court judgment? What are the discretionary powers of governor? What is there any constitutional ambiguity? What are the broader implications of this judgment? And then political and legal significance of this particular judgment. And as usual, mains and prelims questions. So let's start the topic. Why it is in news? Supreme Court on 8th of April 2025 has set aside governor decide. Calling it as illegal and erroneous in law. Supreme Court has clearly said that the act of governor is illegal and erroneous in law. This is a major statement used by Supreme Court, and this was a major setback for governors. Now, what was the background, sir? Tamil Nadu Governor R.N. Ravi, he withheld assent for 10 bill passed by Assembly, and Supreme Court said this is your act, the act which was done by Governor to delay the bills is totally illegal and erroneous in law. That means you are wrong, totally. Then comes the next question. So, what are the provisions in the Constitution regarding this? See, the provisions most important is first is Article 163, then Article 200. We'll discuss in detail. Article 163 says, look at the board please, there shall be a council of ministers headed by CM to aid and advise governor. I repeat, there shall be a council of ministers headed by CM to aid and advise governor, and governor should act on the advice of council of minister. Means governor should always act on the advice of council of minister except where he is supposed to act in his discretion. Discretion meaning act on your own. That means in most of the cases governor will have to act on the advice of council of minister. Then comes the next question. So this is about the advice between governor and council of minister, but this topic is regarding bills. Okay, let's discuss that also. Article 200. What exactly is Article 200? Listen carefully. Whenever any bill is introduced in the house, we normally call it as a bill, but when it is passed by state legislature, it goes to governor. Now governor have choices. What are the choices? One, he can grant assent. That means if he grant assent, the bill converts into law. It clears the thing. Second, he can withhold the assent temporary. Third, if it is not a money bill, he can send it for reconsideration. And fourth, he can keep bill for consideration of president. That means here governor have choice. Now you may say, sir, it is clearly specified. So where is the issue? Now listen carefully. Article 200, if you read it carefully, it clearly says that if the bill is sent back by governor to state legislature and if it is again passed, then governor should give assent. He should not withhold the assent. Then comes the next question. So where is the ambiguity then? Now listen carefully. Please look at the board again. A bill is passed by state legislature, Vidhan Sabha, and if Vidhan Parishad is there, then by both the houses, then it will go to governor. Then so it is as clear. He can withhold, he can grant assent, he can send it for reconsideration if it is not a money bill, or he can keep it for consideration of president. It's quite clearly specified. So where is the ambiguity? The ambiguity is that governor should give assent, but within how much time? There is no fixed timeline specified. The phrase written is as soon as possible. Now what is the meaning of as soon as possible? It is subjective. Someone may say, okay, I am giving it as when? As soon as possible. So when we can consider this? So this was the provision which was mostly misused. This is a provision which was mostly misused by different governors, and this provision allowed governors to delay the bill indefinitely. The bill used to be delayed indefinitely, I am using the word. And where it used to happen? It used to happen mostly in those states which are opposition ruled. For example, in center you have one party government, in state you have different party government. That is At present in center, Tamil Nadu, center we have BJP, state you have Tamil Nadu, there's a different party, Kerala there's a different party, Punjab there's a different party. So wherever there is a different party, this thing used to happen and this thing used to create a lot of issues. Then comes the next question. Okay, so is there any other case before this? Yes. Please listen this carefully. In 2016, means approximately 10 years back, 9-10 years back, in Nabam Rabia case, Arunachal case, Supreme Court has clearly said that governor cannot withhold assent indefinitely. So clearly they have said that you cannot withhold assent indefinitely. That means you have to give assent. And if you are returning the bill, you have to give the message and suggestion for amendment. That means one thing was quite clear made by Supreme Court 10 years back also, that you have to give assent, you cannot withhold indefinitely. In second case, the latest one, state of Punjab versus governor, here they clearly said, Supreme Court, that governor powers are not absolute. Your powers are not absolute. And unelected governor, this statement is most important, unelected governor cannot block the legislative process. Please listen carefully, this topic is already asked many times in the exam for questions. Now don't you think here, first thing, court has clearly said that you cannot keep any bill for indefinitely. Second, your powers are not absolute, clearly specified. And the unelected, so specifically, the state assembly members are elected by people. They are representing people's will. A governor is a appointed person by center, and unelected governor cannot block the legislative process. Don't you think governor, when he is doing such type of thing, he is literally trying to stall the legislative process? Now, what do you mean by stall? To stall means to create hurdles in the process. Means by doing all this kind of activities, governor is literally trying to create issues in the legislative process of the state. And if governor is going to create such issues in the legislative process, then how the state is going to run? Don't you think it is quite expected by even constitution makers also that center, between center and state, governor should act as a link between center and state? But literally, if you check the history in most of the cases, we have seen that governor are literally acted as an agent of center, or via the use of governor, opposite party states are mostly destabilized or problems are created by different political parties. I'm not naming A party or B party. It is mostly misused by most of the parties. It's not expected. See, if you want to play, now you are playing politics. If you want to play politics, it's good. Politicians should play politics. But don't you think a politics should be placed at a place where politics? It should not be played by using the constitutional offices. Governor is not a governor is not an employee of central government. He's not under central government. It's a constitutional post. This post should not be used. If you want to play politics, the best way is to contest election, win the election, and form the government. In center, A party government may be there. In state, B party government. In the same state, people may vote differently for center and state. Let us respect the will of the people. We should not play politics by using the constitutional office. This is most important, and this is thing which was happening. Now, after Supreme Court has saying so many times this thing, don't you think still governor has done same the things? Even last year also, when Justice, if I'm not going wrong, CJI Chandrachud was there, he clearly said, please take decision, else we will have to take call. And finally, in this year's judgment, 8th April judgment, what Supreme Court did, the first and most important, which is going to have a wider implication for years to come, that they introduced time limit. That means now you cannot delay bill indefinitely. Your powers are limited now. State government is becoming have more power than you now. It's clear cut said, because you have misuse. Now even if you want, now listen carefully, let us look at the board again. Even if it is passed by Vidhan Sabha to governor, you have right to withhold for 1 month. But suppose if the bill is passed for reconsideration, and if it is again passed by assembly, then you have to give assent in 1 month. I mean, how much time? 1 month, not 5 years and 10 years of delay. 1 month you'll have to give. If you want to reserve the bill for president, yes, you have right. Do it in 3 months. That means, don't you think by doing all this timeline, Supreme Court has done a great job to all those parties which are in states where opposition party is ruling, because they are fed up with this kind of behavior of different governors. I don't want to name A governor or B governor, because most of the cases we have already seen. That itself means now governor will have to follow time limit, and if governor doesn't follow the time limit, don't think it will show the disrespect to the court judgment, and then that action can be reviewed by judiciary. There is a judicial review is possible. Please remember, judicial review is a basic feature no one can take away from Supreme Court. Not only this, Supreme Court has clearly said in this particular case that the word shall in Article 200 means it's mandatory. You are supposed to give assent. It's not your discretion. You should act on the advice of Council of Minister. And in this case, Supreme Court used one more article, that is Article 142. What's the article? Whenever Supreme Court feels that there's a need to do a complete justice in a case, they use extraordinary powers. And here they have used those powers. What? They clearly said that those 10 bills which were not yet passed for years, Supreme Court said they are deemed to be passed. How? Please look at the board. If a bill is passed by Vidhan Sabha, now it goes to governor. Now Supreme Court is criticizing you, you are not taking any action. Then he is sending for reconsideration. Now second time it's binding on him. But instead of signing, he is sending now to president. Is it right? It is absolutely wrong. Supreme Court says it is not at all correct. And while saying all this, Supreme Court has clearly said that why we did it, because the long delay made by governor. You should not take a time of 2 years and 5 years, because government itself is there for 5 years, and sorry, and if governor is not signing the bill for 5 years, then how the state is going to be run? How the state government is going to do something good or welfare for the people? And Supreme Court has already said in earlier judgment that please follow, please sort out the issues, but you didn't. So don't you think that itself means you are showing disrespect to prior court ruling? And that's the reason court used Article 142 to do complete justice and clearly said all these 10 bills are deemed to be passed. That's it. Now, will there be broader implication? Answer is yes. There will be broader implication for years to come. Don't you think there are many other cases which have similar impact, similar cases? Let's see example. In Kerala, you have left party government. In Punjab, you have AAP party. Telangana, you have Congress. West Bengal, Mamata Banerjee and governor issues, you are already aware. Don't you think in most of these states, governor had literally delayed the bill, assent given to the bill? Kerala case is already running in the Supreme Court and it's more or less similar. And if the case is similar, grounds are similar and things are similar, in that case there is a possibility of same judgment may be applicable. So there will be implication, yes. Will there be political and legal implication? Yes, because this particular judgment, this landmark judgment, has clearly clarified the limits of governor power. Means the first thing it has clarified, governor powers are limited. Stay within limit. You have limited power, and it strengthens the autonomy of elected government. Please always remember, the elected government should be allowed to work. Yeah, governor has right to keep the bill for consideration of president under Article 200, but that is in certain cases. That certain cases, for example, if any bill is violating the constitutional provision, or if it is threatening the unity and integrity, or it's against the part 4 of Indian constitution, that is DPSP. But in most of the other cases which are normal, you have to give assent. And that's the reason this bill has clearly clarified governor powers, that you have limits of the governor power, and it has talked about autonomy of state government. Not only this, don't you think this judgment will act as a binding precedent on future cases, that the delay, the kind of technique which used to be used by different governor, which was the technique that as soon as possible, You say na that I will sign the bill as soon as possible. Now, as soon as possible, court has clearly said that as soon as possible means as early as possible you are supposed to sign the bill. This does not mean that you should keep the bill for 2 years and 5 years. So misuse of discretionary powers will be stopped, or at least it will be reduced to a larger extent. So there will be a tremendous political and legal implication of this bill. Then comes the next question. Sir, if in the mains any question will be there on this particular case, yes. If you have seen the video clearly, let us try to solve one question. The mains question which I expect, that in recent Supreme Court judgment on Tamil Nadu governor delay, Supreme Court, its judgment is a pivotal moment in defining constitutional boundaries of governor discretion. मतलब bill has clearly said talk about constitutional boundaries of governor discretion. So don't you think it talk about the limits of powers of governor? Second, discuss the constitutional provisions. Now constitutional provisions means which are the provisions which we discuss? Article 163, Article 200 and Article 143, which is used by Supreme Court for doing complete justice. Third, how court interpreted the thing and broader implication of this. So don't you think when you are writing answer you should do justice to all these 4 points which are asked in the exam, and that too within word limits of 250. And I'm quite sure that if you have seen the video carefully you can definitely answer this. Then let us try to solve one question on prelims, that regarding governor role which of the following statements are correct on this particular case only. One, governor can indefinitely delay the bill. First. Second, governor has to pass the bill in 1 month in second round. Third, Article 142 is used by Supreme Court for doing complete justice. And fourth, governor can reserve any bill for consideration precedent without any time limitation. Out of these four, which statements are correct? Options are given A, B, C, D. You are supposed to mark the option. If you know the answer, please write it in comment box. If you like the video, please like, share and subscribe the channel. Thank you very much.